please the court, Peter Webster for the petitioner, Charles Lieupo. I'm going to try to save about 5 minutes of my time for rebuttal. This case presents a very easy question of statutory construction, made somewhat more difficult by some imprecise language in this court's opinion in Curd versus Mosaic Fertilizer.
Mr. Webster, let me ask you a question. Before we get and the statutory interpretation, let's assume that I agreed with your interpretation. How is this a question of great public importance?
Well, I
That's
think
how it's before the court, correct?
Well, it is, and I think that the fact that this case cases under this statute have not arisen with great frequency doesn't necessarily make it not a question of great public importance. I think it's far more likely that the reason cases have not come up more frequently is because people, including lawyers, are just not familiar with this statute. And in 1980, when the phrase a question of great public interest was changed to a question of great public importance, the court indicated that it was doing that because some legal issues may be of great public importance and yet not sufficiently known by the public to be of great public interest. Whether Section 376, 313.3 does or does not create a private cause of action for damages, it seems to me ought to be a question of great public importance to everyone in Florida. And I think that if the people of this state were properly educated regarding the statute, they would almost certainly agree that it is a question of great public importance. In addition to that, of course, this court thought the question that was certified in Curd was of great public importance.
Isn't the lack of claims indicative of the fact that people are being compensated outside of this statute for whatever injuries they may have? In other words, what's the great, as opposed to just regular, importance to a statute that isn't utilized by folks and they're quote-unquote uneducated for it? And the other, I guess the related question is, I have not known any lawyer in this state to be shy about using any remedy at their disposal on behalf of their clients.
Well, I mean, it's equally possible that that lawyers in the state believe that this court in Curd did hold that personal injury damages are precluded under the statute.
What about from 1983 until 2010?
Well, I mean, there have been a series of cases involving Section 376, 313. The first was probably the Cunningham case, in which the First DCA concluded that a complaint alleging personal injuries resulting from covered act of pollution under the 1983 Act stated a cause of action. There are a number of cases where the district courts of appeal grappled with the question of whether Section 376, 313 actually created a private cause of action.
And we answer that in error, Mark, I understand. But where, I guess my question is, what separates this particular case and this particular cause of action and this particular line of injuries for an environmental statute, as I understand it, a clean water statute, from just the regular run-of-the-mill cases that are pending in our district courts of appeal?
Well, how can we say the question of whether you can recover personal injuries under the statute is any less important than whether fishermen who own no interest in marine life can bring a cause of action for damages in the form of lost profits?
I'm not saying I necessarily would have taken the case in Curd, but
Well,
that's
I'm
really
not saying I would either, Your
right.
Honor.
Well, but that's sort of the point, which is if we shouldn't have taken it in Curd, then why would we make the same mistake here?
Well, of course, on top of everything else, we have the issue of whether Curd is palpably wrong.
Well, but even if it's palpably wrong, and let's assume that I agree that it's palpably wrong, under the doctrine of stare decisis, how this is not a constitutional question, and the doctrine is at its weakest in a constitutional context where only the court can either correct the error or there has to be a constitutional amendment. This is a statutory interpretation, and assuming that the court got it wrong, there are economic reliance interests at this point based on that opinion. Why should the doctrine of stare decisis not hold?
Okay, well, first of all, Your Honor, if there are economic reliance interests, I sure don't know what they are. This court in Brown versus Nagelhut in 2012,
I'm familiar with it.
and in several of the other cases we cited in our reply brief, the court has repeatedly receded from prior precedent when it concluded that the prior precedent, and the language from Brown is, constituted a serious interpretive error that resulted in an outcome that was unsound in principle. In Brown, the court receded from a prior statutory construction for that reason. In Brown, the court said that it found it implausible that there were any people relying on the statute to decide when and where to violate contracts or to commit torts.
Well, in Brown, the court said there was an extra statutory restriction on the plaintiff's right to select venue, correct?
Brown involved two aspects with regard to overruling the precedent. In Ruffton, the court also in 2016 receded from a prior precedent for the same reason, saying that the doctrine of stare decisis may bend where there's been an error in legal analysis, in citing Brown in the serious interpretive error resulting in an outcome that's unsound in principle. Just last November, this court in Shepard versus State receded from a prior precedent because it concluded that the prior precedent's interpretation of the pertinent statute was simply contrary to the statute's plain language.
So can I ask you a question? I'm sorry to interrupt you. So speaking of bad precedents, what if Aramark was wrong? What does that do to your case?
Well, if Aramark was wrong, which nobody has raised, of course, in which this court wouldn't be in a position to consider on its own today, and which, by the way, was a unanimous decision. If Aramark was wrong, there's no private cause of action. It's as simple as that.
And so what do you think on the merits of that? I mean,
On the merits of Aramark?
Do you think that the statute that says nothing prohibits any person from bringing a cause of action, does that sound like something to you that creates a cause of action?
I think the Fifth DCA in Kaplan versus Peterson way back in 1996, when they were trying to decide whether, in fact, the statute created a private cause of action, got it exactly right. They concluded it did, and they concluded it did because the federal act on which it was modeled did not provide for any right to sue for damages. Whereas this statute in subsection 3 expressly says that nothing contained in the act prohibits anyone from bringing any action they might have for a violation of that.
Isn't that language in stark contrast to the language from the 1970 Act that clearly states that a person may bring a private cause of action under that law?
Well, the 1970 Act was amended to say that in 1996, and the respondents cite a case, a federal decision, Dosty, for the proposition that all that change in the language was intended to do was clarify what the statute's intent had been all along. Frankly, you wouldn't limit the defenses that were available to
Well, I
such
think
a...
it's clear that it obviously was doing something in terms of the standard of care for those pre-existing causes of action. But, I mean, if you were writing a statute to create a private cause of action, you would never begin the statute by saying nothing here prohibits you from doing such and such.
I guess, Your Honor, if the court in the proper case wants to go back and reconsider Aramark, they certainly could do that. That's not this case. It's not been raised as an issue here. The only issue raised here is whether the words all damages in the statute mean all damages, or they mean all damages except personal injury damages.
And you suggest in your reply brief that our answer to that question has something to do with political philosophy. Can you explain that?
I don't suggest that it has something to do. I suggest that...
What you wrote is that if we don't agree with your reading of the statute, that it would suggest that our interpretation is based on the interpreting court's political philosophy.
No, respectfully, Your Honor, that's not what I said.
Okay.
My exact words were, and this is at the bottom of page 1 and the
Right.
top of page 2, ascribing a meaning to the language other than that commonly understood, given the words used, would have an erosive effect on respect for the rule of law, because it would suggest that interpretation of statutes is not based on an impartial reading of the text, but instead is based on the interpreting court's political philosophy.
Right. So
That's Justice Scalia and Brian Garner.
You're starting the sentence by what led up to that was saying that you're saying that what you advocate is the meaning of the language that's commonly understood, and if we don't agree with that, that it must be based on it could lead a reasonable observer of us to think that it's based on our political philosophy.
And I think that's correct. Arriving at a construction of the words used that's not consistent with the plain meaning of those words would suggest that something's going on other than an impartial resolution of the case.
But you agree, though, that we are, at this moment, CURD is this current state of the law?
I don't agree with that because we don't think the court in CURD held that a private cause of action for personal injury damages is precluded by Section 3.
How can you not, I guess let me rephrase it. Justice Polston wrote a concurrence in that case, correct? And he specifically pointed out that the majority was misreading the statute. So how can we then not say that, in fact, the majority, when that opinion went out, when that decision went out, in fact, had under full consideration that argument?
Justice Polston did not indicate or even so much as suggest that the interpretation the majority was using might preclude a cause of action for damages for personal injuries. That was not discussed at all in the case.
But the definition of damages was.
The definition of damages was discussed.
So how is that not a holding of the court defining what damages is? Now, I know that the implications of what that meant may not have been thought through, but the definition itself was very much thought through, was it not?
Well, that's open to some questions since the court relied on a definitional section which by its express language says it doesn't apply to
I'm not saying that the court
1983
is right or not. I'm just saying that the issue was, that issue, the definition of damages, was very much at issue in the case.
It was.
Then how is it? Then how can it be dicta?
Well, if the court concludes it wasn't dicta, then it ought to be clear, I think, that...
Can I ask you something?
Yes.
Related to Justice Muniz's question? Were 5 justices who agreed with that definition acting as political actors or were they based on their political philosophy when they made that decision, including some people who are currently sitting here right now?
I think that the interpretation that was applied in CURD was intended to allow for recovery for consequential damages under the Act. Now, whether the justices intended to do anything more than that the fact of the matter is 4 of those 5 justices voted to hear this case on the merits, and the 5th had previously retired. To me, that suggests something. And to go back to the issue, because if you do think that was the holding incurred, it's just as clear as it can be that if that was an intended holding, that is, that personal injury damages are not recoverable under this section, that was a serious interpretive error that resulted in a decision that's unsound in principle. It just cannot, under any stretch of the imagination, be 1, reconciled with the plain language of the statute, or 2, reconciled with the overwhelming weight of the results of construing the statute. The real problem here is, if you think that's what Curd held, they resorted to in pari materia in a situation where there was no call to do it, because they said they were relying on the plain language of the statute. If you're relying on the plain language of the statute, you don't resort to in pari materia, because that's a rule of construction. They also mistakenly, I think, said that the definition of damage in section 3760315 applied to all of chapter 376, and that's just flat wrong. And I just can't conceive that any court, the job of courts is to correctly interpret the law. And I can't conceive that any court would intentionally deprive the citizens of this state of a remedy that the legislature plainly intended them to have because of a serious interpretive error in a prior decision.
But isn't it stare decisis 101 that when a court misinterprets a statute, that it's up to the legislature to correct the error?
No, I don't think it is stare decisis 101, respectfully, Your Honor.
Aren't there countless cases that basically have that as boilerplate?
And
the court interpreted a statute, and if we got it wrong, Congress/the legislature can fix it?
Not one of the cases that we cited in our reply brief, all of which reversed prior precedent, because the precedent was flatly inconsistent with a plain reading of the statute. In none of those did the court mention legislative inaction, even though in many of those cases there had been inaction for a much longer time. And placing reliance on legislative silence to determine intent is a very dangerous thing to do.
No, I'm sympathetic to that point of view, but I do think I think you have to agree that in stare decisis case, courts don't just look at, did the prior court get it wrong in a statutory interpretation, and if the answer to that is yes, then they change course. You agree with that, right? Do you agree with that?
No, I don't, Your Honor.
So there's only one question for stare decisis, is whether it's right or wrong.
No, I don't think that's right.
Okay, so what's right?
So what's right, according to Brown versus Nagelhut and Rushton, is that, number one, you look to determine whether there has been a serious error in construction of the statute.
So it's not a mere error. It's not any error.
It's not any error.
The analysis has to involve looking at the gravity of the error, correct?
Sure, and it has to also result in a construction that's unsound in principle. Your Honor wrote both of those decisions.
But let me
I
ask
seem
you.
to remember that, yeah.
But Mr. Webster, I'm sorry to intrude here, but the question I have is, even assuming that I agreed with that your interpretation is correct of the statute, the first hurdle we have to get through is the public importance question.
Sure.
Because that's a jurisdictional question.
Sure.
Okay.
Sure, there's no question about that. But again, I don't know what to say other than I don't see...
No, I understand that, but obviously we have to write an opinion, so...
To answer the remainder of the question, the last question you asked, it's not just whether it's a wrong construction that results in unsound decision in principle. You also, according to Brown, you also look at whether there's a significant reliance interest that will be damaged by receding from the precedent. Those are the two things Brown said. And as in Brown, it's just inconceivable here that people will decide when and where to pollute based on whether you have a private cause of action for damages under this statute. There just is no reasonable reliance interest involved.
Well, but I mean, in terms of the type of liability protection that you might get for yourself, there would be a reliance interest depending on what you thought the scope of your exposure might be.
Perhaps.
So,
Perhaps.
I mean, obviously the guy didn't decide to have a heart attack and die when he was driving this truck, but, the company probably looked out at the scope of its exposure and may have taken this law into account.
Sure, except the statute expressly says that, and this court held in Aramark, that
And
it's
this court expressly held in the Curd case or whatever that damages didn't include personal.
But Aramark is not before this court today. The question before this court, the only question, is whether.
I think the comment is that there could have been reliance on the decision in Curd and the holding there, the use of that definition. Counsel, we have helped you use up all of your reserve time plus a little more. I will nonetheless give you 3 minutes for rebuttal.
Thank you, Your Honor.
Thank you.
May it please the court, just going back to the threshold jurisdiction question, this isn't a matter of great public importance. The first issue was the examples that this court has given about the issue coming to courts with great frequency. This issue has only come up one other time in the 36-year history of the Water Quality Assurance Act. So that's the opposite of frequent. So it certainly doesn't meet that standard.
But let me ask you this. Could that be in part because of the Curd decision?
It could be. It could be.
But not from 1983 until 2010.
Not since 1983. And
Because if the language was as clear as day, as your opposing counsel said, then they would have brought all these claims for the 20, my math's terrible, but the 20 or 17-something years that we hadn't decided the issue, right?
correct. And
there's no reported cases on that?
None. And this is also similar to the other example that the court gave of what is great public importance if it involves extant decisional law that it has been leading lower courts to lots of different answers rather than one single answer. And that's certainly not the case here. I mean, if you discharge jurisdiction, there is one single answer to this question from Curd and the Simon Trucking First DCA decision. And it's certainly not a matter of constitutional magnitude. I mean, this issue is about the interpretation the type of damages and the types of claims that can be brought under a very narrow, extreme form of strict liability in a statutory cause of action that only encompasses certain very, specific types of claims, even a specific type of discharge. It's got to be a defined hazardous substance. So this is narrow, and it's not coming to the courts with frequency. It's not a matter of great public importance, and it's also not a case you want to exercise jurisdiction in where you've got a lower court, a trial court, not following binding Supreme Court precedent, right? There may be many opportunities, there will be many opportunities for this court to revisit prior decisions that may have been wrongly decided, but you don't want to bless a trial court ignoring binding precedent when the First DCA said unanimously this Curd decision was brought before the trial court. It is not dicta. it was very clear that this type of claim could not be allowed, and the trial court did not follow that precedent. The way these cases should come up is the attorney at the trial court should preserve the issue. The trial court needs to follow the binding Supreme Court precedent, and then the same thing happens at the District Court of Appeals, but you don't want to have 984 lower court judges in this state ever thinking it is appropriate for them to review Supreme Court majority opinions and pick and choose which ones to follow. So there's an appropriate way, as Justice Clarence Thomas says, to bring up issues and requests to recede from binding precedent, and Justice Clarence Thomas will say often, go get the appropriate case and come back to us. This is not the appropriate case, and that is another reason.
Can I ask you, sorry to interrupt you, do you, if we ignore Curd for a second, do you agree with opposing counsel's interpretation of the term damages in the statute that's relevant here? Do you agree that the Curd court, to the extent that they were addressing it, that by taking the 1970 Act's definition of damages, that was a mistake?
I think that whether we're under Curd, the majority, or Justice Polston's very well-written concurrence, or if Curd didn't even exist, personal injury claims are not allowed under the Water Quality Assurance Act. And they've talked a lot in their brief about just the
Is that because Aramark was incorrect, or is that because any damages would not include personal injury damages?
All damages would not include personal injury damages, even if Aramark was correct. And here's the reason. They've taken the words all damages, pulled them out of the text, read them in isolation. And what I'd like to do is I'd like to put them back into the statute, into this sentence and in this section. And when you do that, you look at 376.313, subparagraph 3, and it is all damages. You can recover all damages resulting from what act? The act is the prohibited acts in the Water Quality Assurance Act. It's the prohibited discharge. And that is defined in the Water Quality Assurance Act. So you go right up to 376.302, and it says the prohibited act is a discharge onto surface and groundwater that damages the natural resource. That's it. It stops right there. Now, and that happened here before Mr. Lieupo showed up at the scene. That's all that's remedied in this extreme form of strict liability in the statute. We all know that in subsequent acts, human beings sometimes come onto the property, onto the contamination, come in contact with the contamination, get injured. And common law tort theories of liability have developed over hundreds of years to provide concepts like foreseeability that we have in Florida and proximate cause to extend liability to those more remote injuries that may occur. But you have to set all those common law concepts aside and just look at what is this text addressing. Look at the whole 28 sections of the Water Quality Assurance Act. It is all of them, they provide 4 different types of remedies just related to the prohibited act. The legislature could have added another section after the prohibited act and said, and in the event of a prohibited discharge under section 1A, whoever has ownership, custody, or control of that contaminated property must take all necessary steps to prohibit human beings from coming onto the property and interacting with the contamination, and if they don't, it'll be a violation of this chapter. That's not in there. You have to stick to the text. Otherwise, and as lawyers and judges, we have a natural tendency when we see phrases like all damages, which they've pulled out and tried to define in isolation, we have a natural tendency to understand those words drawing in our understanding of common law tort theories of liability, foreseeability and proximate cause to extend the liability. It has no place in the text of this statutory cause of action.
Would this line of argument made here be inconsistent with Curd?
I think under the Curd majority or the concurrence, or if Curd didn't exist, the Water Quality Assurance Act text still does not allow for it. Curd, of course, just was addressing damage from the discharge damaging the natural resource. It was not going to any of these subsequent acts like Mr. Lieupo hours after the discharge. I mean, these facts of this case really kind of give a perfect example of this distinction between the primary act that this text addresses, damaging the natural resource, and these secondary acts. Mr. Lieupo after the primary damage that this text addresses has happened. Hours later, he comes to the site and he lays down and takes a nap in the dirt for 45 minutes adjacent to the site where the hazmat team hasn't even cleared it. That's a totally separate act. That's a subsequent separate act not addressed in the Water Quality Assurance Act. And in these facts, he goes on to spray starter fluid on his legs to get ants off of his legs, and he treats himself. These are all things that in the realm of common law negligence, which was the claim they brought initially, page 54 of the record, we would have had commensurate common law defenses, such as comparative negligence, to address all those subsequent acts. But the Water Quality Assurance Act only addresses, in this strict liability claim, the damage to the natural resource. And when I say it's the most extreme form of strict liability, this court established the common law negligence per se strict liability 60 years ago, and it excuses the plaintiff from proving duty and breach. This text under Aramark says you don't have to prove duty, you don't have to prove breach, you don't even have to prove causation. That's what Aramark said. So it's much more extreme, but it's even more extreme than that because the text says no defenses can be brought other than those in 376.308, which are all narrow defenses, none of which apply here. The point of all that is you have the most extreme form of strict liability, so the court has got to stick just to the text of what's addressed. You have to be very careful not to unconsciously import what I think they're doing, unconsciously import those common law tort theories of liability, concepts like foreseeability that would extend the liability. If there are no further questions, thank you.
I'm not sure what the respondent is arguing when it's arguing you have to look at the text, but apparently have to ignore the modifier all in front of damages. I do know that in United States versus James, which we cite at page 3 of our reply brief, the United States Supreme Court rejected precisely the argument about what constitutes damages that respondent has made here. They said that the commonly understood meaning of damages includes both injuries to property and injuries to people.
Well, what counsel, as I understand, is saying is, I think in the main that would be exactly right, but the statute modifies it to limit it to what's in the Act. And the Act itself, in another section, refers to only those things that affect the environment. So that's the argument he's making, but it's not just, but I just want to be clear, it's not just focused on the word all and damages.
The 1983 Act was intended to protect Florida's potable water supply. The 1970 Act was intended to protect the coastal environment.
I understand, counsel.
Because the 83 Act was intended to protect the potable water supply, it makes perfect sense that the legislature would want to protect citizens from personal injuries that they might receive from contaminated water, such as in Love Canal. Your Honor brought up the question of why haven't there been more cases since 1983? Well, one reason might well be that until 2004, when this court decided Aramark, there was a dispute among the district courts of appeal as to whether a private cause of action existed under this statute. So, you saw some cases. Cunningham was one. But because of that dispute, that could easily explain why there weren't more cases. And the reason why there haven't been more since occurred might well be that it's being read as precluding it, although I don't see that. All damages could not be clearer. We ask the court now now to say that all damages in the statute means precisely what the plain meaning of the words say, and to hold that anyone injured by a covered act of pollution is entitled to all damages, including those for serious personal injuries. And we ask the court to answer the certified question in the affirmative, to quash the decision of the First District Court of Appeal, and to remand with directions that the judgment in Mr. Lupo's favor be reinstated. Thank you.
Thank you.
We thank you both for your arguments. Court is now adjourned.
All rise.